Right. Have you indicated we do have some attorneys in the,
Shelley in the waiting room.
all right. Let's go ahead and admit Ms. Ajax. All right, good morning. This is Pasco Municipal Court. Today is February 26, 2021. We are in session on some other cases with individuals appearing in the courtroom. Ms. Ajax is appearing remotely today. Ms. Ajax, are you able to hear me?
I am, Your Honor. Can you hear me?
Yes, I can hear you. Thank you. Just for the record, in the courtroom today on behalf of the city is Mr. Rio and Mr. Quinn Bell. And I see Mr. Luis Ramirez Tovar has approached council table and is present in person today. Good morning, Mr. Ramirez. Council, what are we doing today with this case?
Your Honor, I did receive discovery. I just need to go over that with my client. So I'd request a 1-month continuance.
Mr. Bell? All right. And we actually set those typically on an even dated Friday, so we can reset this again to March 26th. Are you available on that date, Ms. Ajax?
Certainly, Your Honor.
All right. And we'll reset this to that date. We're going to start setting the remote hearings at 10 o'clock because I really don't want you to have to sit around in the waiting room on the virtual courtroom. And hopefully by 10 o'clock, we have the other matters on the docket concluded. Okay?
Much appreciated.
All right. Unless there's something else we need to address, that will conclude our hearing today, Mr. Ramirez. All right. Thank you. You're excused.
Thank you, Your Honor.
We'll provide Mr. Ramirez notice of that hearing at 10 o'clock since he's present in the courtroom today. All right, and you indicate we have Mr. Libert as well. I recall he just has the one case. Go ahead and admit him. Good morning. Are you able to hear me, Mr. Libert?
Yes, I can hear you, Your Honor.
All right, we are here today on City versus Douglas. Mulich. I don't see him in the courtroom yet. Did he intend to be here today?
He did, Your Honor. Let me send him a message saying that the court's ready because we had considered, I think the original we talked about 10 o'clock, so he may not have tried to join yet.
All right. If he's not, I think we do have other matters in the courtroom we can attend to as well.
Okay.
So we can wait until 10 o'clock, Mr. Libert.
Okay.
I'm just going to have the clerk mute you until that time, okay?
That works.
All right. Good morning.
Good morning.
Ms. Mendoza. Are you ready on your case?
Yes.
All right.
Wait, your Honor, Sergio deal with a Moraz.
Yes,
scheduled this morning for a stipulated facts trial. The last time we were before this court, he was in custody being held on a number of superior court cases. My understanding is that he actually resolved those matters on Tuesday. And he's no longer in the jail. So I don't have any other information to provide to the court other than to say he is not in this morning.
you did not represent him on those other
No,
matters. So you're unaware of the sentence that he may have received on those?
I looked up in the notes I could access this morning. From what I can tell, everything was concurrent.
All right,
And he would have had credit for time served, given my knowledge of the time that he's been in custody.
all right. Mr. Rio, what's the city's position on this?
Your Honor, I'm asking for a bench warrant. This is a necessary hearing. And he's given notice to be here. This is the trial date. And under the willingness ruling, trial is a necessary hearing.
Dinner, I'd ask for as low a bail as possible, and then I will attempt contact with him at numbers that I've had to see if I can perhaps get him back here before the court.
Based on the record made here today that today's hearing is a necessary hearing, the defendant has failed to appear. I'll issue a bench warrant. I'll set that based on your request of $350 cash or bond. All right, thank you, Ms. Mendoza. I did see Mr. Eisinger, yeah, Eisinger present.
Yes.
All right. You need a moment, Mr. Rio? All right, we can give you just a moment. Yes. No, yeah, I think you're fine. We're gonna take your case next. Yes, thank you for checking to see if you have any other, if we have any other needs. Just so I make sure I'm on the right page here, I have notes that indicate this was a reset for a stipulated or continuance review. Is that correct?
This is on for bench trial.
All right. Is it on for a bench trial today based on an agreed revocation of this?
That's going to be my understanding. I'll let Mr. Eisinger. I think that they're in agreement that he didn't get treatment.
Mr. Eisinger?
This was an SOC entered in January of 2018, and at this point, Your Honor, we are stipulating to revocation.
All right.
And we would like to go ahead and proceed forward.
Walker.
And let me know, Mr. Rio, when you're ready to proceed. Okay.
The judge, I'm
Thank you.
handing up an amended complaint which sets out the essential elements of destruction of property, domestic violence.
And just for the record, I believe that in between the time of the charges here and today's date, portions of the Pasco Municipal Code were recodified. So the new code is actually 9.115.090.
But I don't believe I can amend to that because it wasn't in effect at the time of the trial.
I'm just so everybody is clear that there was an amendment in between then and now. I think it effectively just changed the place of it, and nothing else changed.
Correct. It's not
Yes,
changed the language of the statute, just the location of that particular charge in the code.
yes. All right. Mr. Eisinger, you have been provided a copy of the amended criminal complaint. Any objections?
Your Honor, this comes as a surprise to me. I was not advised that this would be done today. I can tell the court that his name and date of birth are correct. We will enter a plea of not guilty and waive a formal reading. And without having the opportunity to fully detail my objection, I will just simply note on the record that we are objecting to the filing.
And the basis.
The basis is that it's untimely and that my client is deprived of his due process rights and ability to fully defend his case.
And Mr. Rio, the basis for the amendment is,
Sure, just the essential elements. I didn't change any facts. This has been in the police report. This particular allegation has been the allegation since day one. Regarding what was damaged, there's photographs in the report showing what was damaged. And so I don't see the prejudice to anyone in that this was, the reports were given to Mr. Eisinger, and this was the allegation all along.
thank you. I believe the request amendment complies with the rules in this case. I'll allow the amendment. I will note your objection, Mr. Eisinger. Any other preliminary matters we need to address before I review the facts?
Now you're.
All right, thank you.
Before we do that, if I can just inquire what you're reviewing for that purpose, maybe we can make a record of those documents are actually already in the court file or provided, or what exactly your Honor is looking at.
I have been provided today an amended criminal complaint along with a incident investigation report setting out a incident number 17-52195. It consists of 5 written pages. On the first page is more of a cover sheet. The second page is a continuation of the cover sheet with portions of a report by Officer Santiago. The fourth page is a continuation of, it looks like reports from the dispatch or excerpts from dispatch. The fifth page just indicates that this was copied and sent to the city attorney. Attached to that is 1, 2, 3, 4 photographs And then also a domestic violence victim statement from Mr. Lyndon Torsia. And then a copy of the original charging document with the attached approximately 2 pages of, for the affidavit of probable cause.
And I believe Mr. Eisinger has an exact copy of that when he sent it.
All right, thank you.
Yes, I do. I just wanted to make sure that you were drawn with it.
All right, thank you. I'll take a moment and review the police reports. All right, council, I have had a chance to review the reports and documents handed up by Mr. Rio. Any argument, Mr. Rio?
Just ask the coordinator. In this case, I guess, that if we have a father and son, I will say yes. I want to make some argument. We have a situation where Mr. Torsia and Junior, sorry, not saying that right, Lyndon Torsia and Michael Torsia are living together. The senior Mr. Torsia has to lock himself in a room. The cabinet is broken. Mr. Michael Torsia said that he broke the cabinet. It's his father's home. It's his father's cabinet. And so based on that information, we're going to have to
Mr. Eisinger?
Thank you very much, Your Honor. I will need a few minutes to go over this because there are some things to discuss. I think it's important on an SOC bench trial to start by looking at the SOC and acknowledging that it says right in the document that it is not an admission to guilt, and that in the event the court revokes the SOC, that there'll be a finding by the court of either guilty or not guilty. So we're here and
Yes.
in the context of a trial, although it was stipulated facts trial, but it's a trial like any other where you're determining beyond a reasonable doubt whether he's guilty or not guilty of the offense. I think there's some very important things to point out here. So that the charge that he has been accused of is for willfully destroying property that's not his own. So when we look at the evidence in this case, actually it doesn't say in any of these reports that this display cabinet belongs to the father, Lyndon Torsia. In fact, the report indicates that both of them reside at the same address at 4712 West Marie Street. And I think taking this from the top in terms of how the report describes the incident is important. So according to the report, at 2302, officers are dispatched. The dispatch is concerning in the way that it sounds, but again, a person's not guilty just because a situation may be difficult or there is an argument. There has to be evidence of the crime that they're charged with. So the concern is that the father calls in and says his son has mental issues and is destroying things. And then I think it's important to note when the officers arrive, the location of certain things. So the officers make entry into the home. The report says they see a male standing halfway. They enter into the hallway. So that's the first location we see here. Then they enter, and then they see a male halfway or partially into a bedroom. He's wearing a t-shirt and underwear. And they see an older male that's also in a bedroom. So apparently the initial contact, the officers come in the door, they walk down the hallway, they're seeing two people in bedrooms. There is a conversation that the officers have with each of these persons. And then the older male, Lyndon Torsia, says that he was in his room and he had to put a piece of furniture behind the bedroom door. So that's where he is when the police arrive. However, one of the officers talks to my client, and according to the report, my client says he broke a piece of glass in this display cabinet, and they asked his father about this piece of glass. And this display cabinet isn't located in the hallway. It's not located in either one of the bedrooms. According to the report, it's located in the living room, which is not where anybody is at the time that the officers arrive. And we can see from the photographs that it appears to be in the corner of the living room. There is very, very, very minimal discussion of this display cabinet in the report. And I'll refer the court to that part of the report. If you look at what's marked as page 3 of the typewritten narrative,
Yes.
the third from the last paragraph is the only part of the typewritten narrative that discusses the display cabinet. And it notably that part of the report doesn't say how the glass was broken. It doesn't say when the glass was broken. According to, in the last sentence of that paragraph, it says that the father said it happened, quote, earlier in the evening. And this investigation is happening again between 11 o'clock and about 11:20. And it gives us absolutely no indication that this related to the 11:02 dispatch that was sent out to the officers. So we know none of those details. And the problem that creates is, again, not knowing whose cabinet this is. We can't say whether he destroyed property that was not his own. They both lived there, and it doesn't say in the report. And again, since this happened earlier in the evening and there are no details of how it was broken, we don't know if this happened innocently and accidentally or in a more intentional or malicious manner. So as an example, we don't know if the cabinet was simply being opened, it was being moved, maybe somebody bumped into it, or was this done with a more malicious or intentional intent? And none of those details are stated. And that is one unfortunate reality of how these SOC trials work, is that the defense is limited by the reports, but it also indicate for the court, I mean, in this case, so is the prosecution. So I would suggest to the court that there is insufficient evidence that he committed the crime for that reason. In addition, since the city has finished the briefing of its case, I would like to hand up a motion to dismiss. And that motion is based on preemption of the city ordinance by state law. State law criminalizes malicious mischief in situations where a person acts maliciously and destroys the property of another. And in this case, we have a city ordinance that lowers that standard, and it criminalizes not malicious behavior, but it criminalizes willful behavior. Both the case law and the pattern jury instructions are clear that willfulness is synonymous with knowledge. So what that means is that according to this Pasco ordinance, mere knowledge alone is sufficient to constitute the crime of destruction of property. Willfulness is not defined by state law, and it's not defined by the Pasco Municipal Code. But there is clear case law under with it that describes, again, it's synonymous with knowledge. Maliciousness is described, and malice under the state criminal code means to have evil intent. So malicious mischief under state law, if this were charged in Franklin County District Court as a malicious mischief third, would require evidence of not only destruction of property not his own, it would require evidence of a malicious heart, that this was done with malice or evil intent. And I think that that's significant when we consider yesterday's Supreme Court decision, State versus Blake. In State versus Blake, our state Supreme Court invalidated Washington State's drug possession laws. And the reason it's significant is that the state Supreme Court said that every other state requires some mens rea in order to commit felony possession of the drug, whether it's knowledge of the drug or intent to possess the drug, some kind of mental state. State law in Washington has not required a mental state for a simple possession case for many, many years. And that was struck down yesterday for a couple of reasons. One of the reasons, again, dealing with due process, was inconsistency with the laws of all of the other 49 states of this nation. And I would submit to this court that we have a situation where the general laws in the state of Washington require a showing of malice for malicious mischief, and that this while the statute does not expressly preempt property crime like destruction of property, it does create a conflict, and that's described in the law as conflict preemption. And the law, in specifically the city of Pasco versus Ross case, which was decided a few years ago, entailed this, that a city may pass an ordinance that prohibits conduct that's not prohibited under state law. However, that law must not conflict with state law. In Ross, the city of Pasco's ordinance did not require proof that the assault was committed unlawfully, and Division 3 struck that down because it was in conflict with state law. In another case decided more recently by Division 3, the White case, that court upheld a Spokane municipal ordinance that instead of requiring intent, required a showing of willfulness for purposes of Spokane's assault statute. I would submit to this court that it is inconsistent with state law, and state law has preempted, by way of an irreconcilable conflict, Pasco's municipal ordinance. And the Pasco's destruction of property ordinance is unlawful as a matter of law. And the reason for that is that it is entirely possible for a person, I'm sorry.
Send her back, please. Go ahead and send her back.
It is entirely possible for a person to commit, to destroy somebody's property without malice and with knowledge, and apparently violate this municipal ordinance. What does it mean exactly to destroy somebody's property with knowledge? That's hard to say. Does that happen when I accidentally bump into something and I'm aware of a fact? That's the definition of knowledge or knowing, is having an awareness of fact, or a reasonable person in that situation would be aware of a fact if they observe these things. If I bump into this cabinet accidentally, am I doing that knowingly? If I accidentally drop it while I'm moving into the garage, is that a knowing act? For all of these reasons, the creation of a criminal statute in Pasco that is at a much lower standard, I would submit to the court, lower than intent, but also far lower than malicious, again, conflicts with state law. So for all these reasons, we're asking not only the fact that there's no evidence of whose cabinet this is, we have no details about how it happened and whether it was malicious or not, and it is absolutely preempted by state law.
Mr. Rio, I do see that Mr. Eisinger's motion to dismiss is signed and filed here today, and indicated that he just served a copy on you. Do you want an opportunity to respond?
Well, I can respond to a couple of things, Judge. First, the statute doesn't just say knowingly, it says willfully. Mr. Eisinger said, is quoting the Whitnick saying, one acts willfully when they act with knowledge, but this says you have to willfully do it, not accidentally. You keep saying, well, if I bump into something accidentally, that's not willful. It's not the use of someone's will. But what's interesting, I think the counterpoint to that is, so I can go up and smash your window, Judge, as long as I say, I really like you. There's no evil intent. I just want to break your stuff. So what we did was take the malice out. I don't have to prove what they say here, which is evil intent. I have to prove you knew it wasn't yours and you damaged it willfully, not accidentally. And so from that point of view, Blake doesn't apply to this case, because Blake specifically says that knowledge would have been enough, that you knowingly possess a controlled substance. And so when you look at that case, they said there was no intent at all. And a lot of courts, because I started looking this up last night at around 10:30 when I read all 63 pages of the Blake opinion, that most states don't use intent. They use a combination of knowledge. You have to knowingly possess a controlled substance. That's where the unwitting possession came from that they were having so much trouble with, was that you had to know what it was. And so I think from this point of view, we do have a statute that someone can understand and can violate without doing it innocently. This innocence test that the court came up with regards to innocent, passive non-conduct, I think was the phrase that they used. And so this isn't a non-conduct case. And that's what Blake was specific about. And they says multiple times, even in the majority opinion, that this opinion doesn't apply to conduct cases. This case only applies to passive non-conduct cases. And so I'm actually surprised I remembered all that from the opinion as I read it, but that's what it said. And this isn't a passive non-conduct case. So Blake doesn't apply. And so we're going to ask you to deny the motion regarding the motion of dismiss.
All right. Thank you, gentlemen. I would say at this point that I think there's sufficient facts contained within the report for make a ruling without having to rule on the motion to dismiss. In reviewing the facts, I read them much as Mr. Eisinger pointed out, in that there's very limited information contained within the facts of the report that discuss the cabinet itself. Although Mr. Linden Torsha does say in the call that my son has mental issues and is destroying things, he doesn't identify the things that he is destroying, nor does he say he's willfully destroying those things. He just says he's destroying things. The balance of the report, other than the one paragraph, talks about an attempt of Mr. Michael Torsha to gain entry to the room. And initially I was thinking, as I read this, that this was a cabinet that was placed in front of the door, knocked over by Mr. Michael Torsha in an attempt to gain entry into the room. I would certainly think that that would be willful conduct. But even if I found it willful, the officer doesn't identify who the property belonged to. And that's a little bit troublesome. He does say that my son and I reside here together. Okay. So for those reasons alone, without addressing the motion to dismiss, I do find the facts are insufficient for me to find beyond a reasonable doubt that Mr. Michael Torsha is guilty of the destruction or removal of property. So I find him not guilty. I guess I should finalize that.
Thank you very much.
Yeah.
I follow that, Your Honor. Is
All
there
right.
some document that the will prepare that reflects the
If you wish to prepare something and present it, and I don't have a problem with that, I'm not going to make any written findings at this point. But if there is some reason, like the city wishes to, appeal the decision, I think that would be appropriate. Or if you have some issues that you want to address beyond this court, that would be appropriate. I'll leave it up to the parties.
necessary? Thank
All
you for
right.
your time.
I think I'm prohibited from any sort of.
I think you are as well. So
Thank you very much, Your Honor.
thank you. All right. It is now 10:17. Is Douglas Mulich present today?
Your Honor, I think he's waiting to be led into the courtroom.
All right. Thank you. All right, I see that Mr. Mulich is attempting to connect audibly to the remote hearing. Yes, Mr. Corbin represents. All right, Mr. Mulich, I see that your microphone is muted. Just for the record, Mr. Bell, Mr. Rio are present on behalf of the city of Pasco in person. Myself, my clerks, and other court service specialists are present as well. Mr. Libbert is appearing remotely. And Mr. Muelich is appearing remotely as well. So please unmute yourself, Mr. Muelich, so that you can respond. And can you hear me all right? Mr. Muelich, you are still muted. So if you're attempting to communicate with us, we are unable to hear you.
Can you hear me now?
Yes, we can hear. Are you able to hear us?
Yes.
Mr. Libbert, go ahead and speak as well. I want to make sure that he can hear each of the individuals present today.
Mr. Mueller, can you hear me as well?
Yes.
And Mr. Bell? I just want you to communicate so I can determine whether or not Mr. Muelich can understand and hear your conversations. Mr. Muelich, are you able to hear Mr. Bell?
I can barely hear him. If he can speak up just a little bit.
You'll need to, no, even speak into the microphone so that we pick it up over the system here, and I think that may be sufficient. All right, and if needed, I'll repeat anything that Mr. Bell might have to say. I know that this matter was reset from the 22nd for entry of a stipulated order of continuance. Is that still the plan?
It is, Your Honor. And I realized this morning that I didn't know how you guys tend to handle the documents for this. I emailed copies to the court clerk as well as to Mr. Bell. So I believe there's at least an electronic copy. Then I realized I have the original in my possession at this time.
All right, and unless you communicated that to the clerk, I don't know that anybody checked for those.
I'm sorry, I hate to cut in, but
Oh.
Ms. Porras came in, that was what she was talking to me.
Okay.
During the last hearing. The document was not scanned in, it was a photograph that was sent. And she asked me to try to print it because it was sent to me as well. And it won't print, it only prints a quarter of the page up in the corner. Because it's a photograph, it won't allow us to shrink it. And so there's no way for us to, I can show the court.
No, I think I understand what you're saying. I think I've observed or seen the same issues in my own use. Mr. Libbert, we don't have the document present today for entry of the SOC. And I recognize that we set this very quickly from the 22nd of February, and I'm sure you did your best to make sure we had something today, but we can't actually print the format in which it was sent.
Okay, Your Honor, and speaking with my client since Monday, I understand that his plans have actually changed a little bit because before we talked about him traveling back and forth from West Virginia, but I understand now that he's actually moving back from West Virginia. And so it may make sense at this point to actually just reset an in-person hearing. I think he's intending to move within a week or two. So maybe we just reset it in person, then we can make this work.
All right, so let me take a look at my calendar here of dates. I will say we're very heavy in March, unless there's some urgent reason to do otherwise. I'm inclined to reset it to April 12th. To the regular docket, give you enough time to speak with Mr. Muelich, have the documents prepared and be ready to enter them at that time. Is that something you would be willing to do, Mr. Muelich and Mr. Libbert?
Yes, sir.
April 12th works. I think that was about the time frame we were considering on Monday as well. So.
All right. So I will indicate today that based on the agreement of the parties, well, I didn't ask Mr. Bell if you have any objection to that date as well. No, all right. Based upon the agreement of the parties, we'll reset this to an in-person hearing on April 12th. Since all parties are here, that will be without any notice from the court, and that will be at 8:30 in the morning, Mr. Muelich.
Okay.
So unless there is any other business on this particular hearing we need to take care of, that will complete our hearing today.
That's all for me, Your Honor. Thank you.
All right, thank you. And you are excused, Mr. Muelich. Thank you.
Thank you.
Is that our last remote hearing? Oh, is he appearing on Mr. Davila? Thank you. Oh, I see. It looks like that was for a pre-hearing conference. Okay. All right, let's allow Mr. Corbin into the courtroom. See, Mr. Davila is present, so go ahead and come forward to the table, Mr. Davila. All right. Good morning, Mr. Earl. You are muted. Okay, there you, well.
Thank you. Got it.
All right. Are you able to hear me all right?
I am. Thank you.
All right. And just for the record, you are present here today remotely. Mr. Davila is present here at council table in person. This matter is scheduled today for a pretrial hearing on Mr. Davila's case. What are we going to do today, counsel?
Your Honor, that's a great question. The difficulty has been that Mr. Davila does not have a phone, or if he does, he has not shared that number with me. If he would like to move forward with trial, I'm fully fine with doing that, but our contact has been non-existent, so I'm not exactly sure what he would like to do.
Do you need some time to speak to Mr. Davila today before you make any decisions? Do we have
If we could, momentarily set aside in a room, that would be great. Unless Mr. Davila knows that he wants to proceed forward with trial right now.
Mr. Davila, have you been able to hear Mr. Earl's comments?
Yes, I think that one number you want to touch me.
You have a phone number? Are you ready to provide that to Mr. Earl right now? Okay. Go ahead.
509-212-8109.
So 509-212-8109.
509-212-8109.
And Mr. Davila, you understand that this is a criminal charge pending. You need to communicate with Mr. Earl. I know that Mr. Earl has actually terminated his contract, and you are one of the cases left under that contract that he is required to follow through. So you need to make sure you make contact with Mr. Earl so he can discuss this case with you, and you guys can decide how you want to proceed. Mr. Earl, do you want to provide me with your contact phone number so we can provide that to Mr. Davila as well?
Yes, please. It's 509-765-1705.
And Mr. Davila, I'm going to assume that you would like to talk to Mr. Earl before you decide how to move forward on this. Is that correct?
Yes.
And Mr. Earl, could you make yourself, we're setting these remote hearings right now on the even Fridays at 10 o'clock in the morning. Would you be available? Let me double check the other dates we have. It looks like we have the 12th and the 26th for next month.
The 26th would be better. I am gone on the 12th.
All right, so let's reset this to 3/26. Mr. Davila, it is very important that you get in touch with Mr. Earl to discuss your case with him so he knows how to proceed. Do you understand that, sir? So we will reset this to March 26th. I'm assuming, Mr. Earl, you would like to appear remotely as well at that time.
Yes, please.
All right.
Yeah. Thank
So
you.
we'll reset to March 26th so that you can discuss the case with Mr. Davila and determine how to move forward, either in some resolution or for setting dates at that time.
Perfect.
All right.
Thank you.
Mr. Davila, we'll give you a notice of that next court date today. And again, get in touch with Mr. Earl, okay? Yes, at 10 o'clock. All right. And Mr. Davila, Mr. Earl's phone number is included on the notice of the court date that the clerk has prepared, okay? All right. If there's nothing further, that will conclude the hearing today, and you're
Thank you,
free
Your
to
Honor.
go. Thank you, Mr. Earl. Thank
Have a
you,
good
Mr. Davila.
Assuming that the person we have in our waiting room is Mr. Harmon on his cell phone.
I see it's set for a pre-hearing conference. Council, we can notify Mr. Harmon that we have a couple of other cases pending, and then I'll take a recess and step out of the courtroom if you want to speak to him at that time. All right, so if you can let him know that we have a couple of other cases to handle before we get to his case. Who is was our provisional today? All right. We're going to go ahead and move on to the gentlemen who are in custody today. We'll start with Mr. Christian Young. Mr. Young, if you'll stand where you are, please. Sir, you are here today on a charge of destruction, removal of property, domestic violence. That is a gross misdemeanor. If convicted of that, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for a conviction of this offense. You do have a number of constitutional rights that were played before court started. Were you able to hear and understand those rights? And you've had a chance to talk to Mr. Huey today, and after doing so, have indicated you wish to plead not guilty. I don't see an application in the file for court-appointed counsel, so does that mean you will attempt to hire your own attorney? All right. Just one moment while I finish reading the affidavit of probable cause. I have reviewed the affidavit of probable cause. Counsel, any chance to review that? It's no indication about whose residence it was, whose property was damaged to. It's a very, I can read the entire 4 sentences. On February 25th at 7:32 hours, officers were dispatched to 5312 Jackson, Pasco, Washington for some type of domestic disturbance. While there, Christina explained her 24-year-old son, Christian, was out of control. He broke her bed bench by flipping it over and break 2 legs off. He then threw himself into the wall in the hallway, causing 2 large holes in the drywall. He threw himself over the 2nd-story balcony and fell to the floor. Christian was arrested and booked for destruction of property DV. Christina does not want a no contact order. The problem I have with that is there's no indication about whose apartment it was, whose property it was. And so it's difficult for me to make a finding that there is probable cause in this case.
You know, at least the police report that's included in the file, that's,
Are you prepared to supplement the record today then, Mr. Bell?
if I could just have a moment to review, I don't have the file. I believe it's-
We'll move on to Mr. Gene Walker. He wants to review the police reports. All right, Mr. Walker, good morning, sir. You're here today on cause number ending in 6718, charged with driving a license suspended in the 3rd degree and driving under the influence of intoxicants. I don't have a copy of the charging document either. I'm looking to see if I don't have a copy of the infraction in this, or excuse me, there's no copy, there's just a booking photo. There is in Jabs an affidavit of probable cause. I'll take a moment and review that as well. I looked, there's just shoplifting charge. Other, stock. Mr. Bell, are you handling these in custody or Mr. Rio?
I'm primarily.
All right. I have had an opportunity to review the affidavit of probable cause that was submitted on behalf in cause number 1A02866718. Mr. Gene Walker is charged with driving while license suspended in the 3rd degree and driving under the influence of intoxicants. I do find, based on the documents provided here, that there is probable cause for the driving while license suspended in the 3rd degree. I'm having some difficulty finding probable cause in the driving under the influence charge because there's no description of the driving that the officer observed. There's a description of by the officer that there was no change in the pupil when a light was used to observe the eye, and that the male indicated that he took 30 milligrams of oxycodone that morning for pain. This appears to be 1840 hours at night at the time of the contact. There is a recognition that says, or a conclusion that says, at the conclusion of the evaluation, it's my opinion that he was under a WSP certified IACP credentialed drug recognition expert, that Walker was under the influence of a narcotic analgesic and unable to operate a motor vehicle safely. But there are no facts on which the court can draw that same conclusion. I mean, that's exactly what it is. It's an officer's conclusion that he was under the influence. No facts to support that. And there are no reports contained or been forwarded in that case. For the record, Mr. Walker is also here for cause number XE0850992, a shoplifting charge. Probable cause was found on that case on December 2nd, 2020. Mr. Walker failed to appear for an arraignment hearing on December 8th, and a warrant was issued for his arrest. A bail is currently set him out of $500 on that case. Mr. Walker, I can go through with you on that shoplifting charge. You're charged with that. It is a gross misdemeanor. If convicted of that offense, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction. The driving license suspended 3rd degree under cause number 1A02866718 is a misdemeanor punishable by up to 90 days in jail and a $1,000 fine. Again, there is no mandatory minimum sentence for a conviction of that offense. You do have a number of rights as a result of these charges. Were you able to hear those rights when they were played before court started? And you've had a chance to talk to Mr. Huey today, and after doing that, have indicated you wish to plead not guilty and request the court appoint an attorney. I will enter a plea of not guilty on your behalf and appoint Miss Summer Rife to represent you in these matters. We're going to address that in just a moment. I'm going to give Mr. Rio and Mr. Bell an opportunity to review.
I'm waiting for Ms. the board act to send me that report. I don't have a copy of it. It's supposed to be coming in my email. She was sending it right away. With regard to the theft case, I'm sorry, the theft case, I'm gonna ask the court to impose the other criminal law violations he here for court dates that he not go back to 801 West Columbia Street in the city of Pasco. If I remember it, that's Goodwill. Is that right?
Griggs.
So not to go back to Griggs, Judge. He does have significant warrant history. He's got outstanding warrants on multiple cases. 3 in Kennewick, 1 in Yakima Municipal, and a burglary second warrant out of Benton County. With that, I think the $500 is appropriate.
Mr. Huey, with regard to the shoplifting charge.
Let me start, and you can add, okay. Mr. Walker is 59 years of age. He's been fighting cancer for a number of years. Based on what he's told me, I think he might not be the greatest inmate, just given the COVID situation. I think he's placed in high risk. He doesn't have any money for bail. He's been on SSI for how long? 20 some odd years. He makes a little under $800 a month to live off of. I'm not sure if he's homeless now or not, but he has been in the Tri-Cities for about a year and a half. So we're hoping, given this age and the fact that he has significant medical violence, the DUI will address that, not that that is a kind of violence. We're hoping that he can be hard on this particular case. I don't think he's going to take it over to Benton County. One, because controlled substance case, I'm not sure if you heard, is unconstitutional.
Yes.
That they want to be referred. I'm not sure what they're doing with those cases in the Superior Court. And that case is, I think, Benton County is taking them over on just this that case is on warrants. You want to add?
I've been sick and really wanted also like to move other than that. But I'm moving being also a caregiver is with me. She died with black.
Are you currently living at the Loyalty Inn?
Yes, 294, I live in that room.
Oh, the Loyalty or the Tahitian?
Pardon?
The Loyalty Inn or the Tahitian Inn? All right.
Like I do have a caregiver and student driving around. I'm really about, but I had a heart attack. Yeah. Took me into the hospital. Being assisted and everything was this. I had worked in my position at hotel.
Well, Mr. Walker, you have a horrible history with regard to appearing in court. And the issue is you continue to commit violations or criminal violations or be arrested for those. You have a pending burglary charge from October of last year. You have a pending shoplifting charge from November of last year. And now this driving while license suspended and DUI of this year. You say you are battling cancer and having difficulty, yet you're out in the community allegedly committing criminal violations. I'm not going to ask you about the facts of the cases. I'm discussing with you some reasons of why a request for bail is an appropriate request. Is you don't come to court and you can continue to commit criminal violations. Now, I am going to take into consideration his advanced age, the medical issues that Mr. Huey has addressed, specifically the Supreme Court's most recent order did indicate that courts should consider those things when setting conditions of release or whether or not an individual should continue to be incarcerated. And it's for those reasons only that I'm going to release him today on the charges. I am going to set a hearing that would otherwise, I would reset a little further out to March 15th. Because Mr. Walker, you need to stay in touch with your attorney. You need to make all of your court dates. If we have issues with you not coming to court in the future, it could land you in jail until your cases are resolved. Do you understand that? You're not to go back to Griggs. You're not to consume any alcohol, marijuana, or non-prescribed drugs. Do you understand those conditions? It's actually any Griggs or Ace Hardware stores in the Tri-Cities. And for the record, we'll move on to cause number ending in 6718. I have found probable cause for count one, the driving while license suspended in the third degree. Mr. Rio, do you wish to supplement the record with regard to the driving under the influence charge?
Your Honor, I do. I'm just reading through Officer Cobb's report. He's the DRE in this case.
When you're ready, I'll swear you in. All right. In the meantime, I will appoint Ms. Rife and continue this case to March 15th as well. In addition to that, staying out of Griggs, you're not to drive without a license or insurance. You are to make all your court dates. Specifically, you're required to contact your attorney within the next 10 days and then contact that attorney every week or as directed by your attorney. A failure to abide by these conditions could result in your incarceration or other modification of your conditions of release. Not yet. Paperwork wise, yes, but we need to do a probable cause here. All right, Mr. Rio, if you'll raise your right hand, please. You swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? All right, go ahead, Mr. Rio. And for the record, this is additional facts to the affidavit of probable cause and cause number N1A02867118 for the purposes of probable cause.
Your Honor, I'm looking at a police report from Jeffrey M. Cobb, Hall 60, from the Pasco Police Department. He's a drug recognition expert. His report states that he was evaluating the defendant at the Pasco Police Department in Pasco and Franklin County in a room at the police department. The dark room portion of the evaluation was conducted in the adjacent restroom, and the door was closed and the lighting was turned off during that. The officer stated that he contacted the defendant after being asked to come to the scene by Detective Boykin. Detective Boykin had contacted the vehicle in the Loyalty parking lot. The officer arrived, contacted the defendant, Officer Cobb arrived, contacted the defendant. His movements were methodical and difficult and hard, he says. I walked him out back to my vehicle and placed him in the right rear seat. Discussed some information about where he'd been that day. I asked him what medications he took. He informed me he'd taken 30 milligrams of oxycodone that morning for pain. He stated he had several medical issues. With my observations at that point, I believe he was under the influence of unsafe to drive. I took him for an observation at the police department. The officer states that he did not do the normal field sobriety test due to his inability to do those things. He did a modified Romberg balance where the defendant estimated 23 seconds during the elapsed time of 30 seconds. They did a modified finger to nose in the 6 attempts. The first attempt, he was unable to follow instruction and put a finger pad to the right side of his nose rather than the fingertip. He then, on the second attempt, fingertip to his left mid nostril. Third attempt, fingertip to left side of nose tip. Fourth attempt, fingertip to nose tip. Fifth attempt, fingertip to the left side of nose tip. And the last fingertip to the under his nose tip. The officer then looked at he was missing his right eye. During the contact in the dark room or light, the officer stated that his pupil size did not change in any lighting condition. And so, and that the size of the pupil was below the average DRE range when it was measured. The big report, so I'm trying to go through it quickly for you.
No, I appreciate that.
In section 11 of this report, the officer says, opinion of drug recognition expert. It's my opinion as a certified drug recognition expert that the subject was under the influence of a narcotic analgesic at the time of my evaluation. Due to the impairment of the narcotic analgesic, he was unable to operate a motor vehicle safely based on his observations. So that's what I have, Judge, with regards to officer Collins' evaluation.
All right, Mr. Huey, any comments at all?
Well, I'm always in favor of, for our capable facts. I think that's what the court will call for. It doesn't really offer, ask for a summary of the facts or conclusion of statements of opinions of officers. It asks for articulable facts to prove the elements of the crime. And this particular case, we didn't have ERE experts report in the file review. I don't know where it's at in JABS, or if he's looking at it in JABS or not, or some other system, but it doesn't seem to add a lot more than what's in the PC statement that through concern review, that a lot of them are just conclusionary statements. Doesn't say how the oxycodone taken at that time, in their opinion, time, place, just says oxycodone. So I think there is concerns about the articulable facts of the effect by narcotics element of the crime, but actually to find no problem.
All right, thank you. I'm going to indicate this time that based on the Romberg test, the finger to nose test, although it's, I think, very minimal, I think there is sufficient information or facts there on which I can find a minimal facts to support probable cause in this case, and so I will find probable cause. Again, however, I am based on Mr. Walker's medical condition and no other reason authorizing his release for him to appear on March 15th. We'll provide you with that information for to contact your attorney and these conditions of release. Mr. Walker, thank you. All right, Mr. Rio, are we ready to, or Mr. Bell, are we ready to resume on Mr. Young?
Yes, sir. It'll be me.
All right, and so I have been handed the file with regard to the destruction removal of property, domestic violence, and Mr. Rio has amended this to include a second charge of simple assault, domestic violence. Mr. Rio, as I indicated, the affidavit of probable cause, I was unable to find probable cause for the destruction and removal of property. There's a second charge now of simple assault. Will you raise your right hand, please? You swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? All right, Mr. Rio, please state the facts for a finding in this case, please.
The facts are laid out in the report that the court has in its file. On the day of the event, the officers were called to the family home where this defendant lives with his parents and with his younger brother, who's 17 years old. There was an argument between them. The police report stated that the defendant pulled the chair out from underneath his 17-year-old brother, causing him to fall to the ground. That's the basis for the assault and domestic violence charge. Additionally, Christina Young stated that the defendant came into her bedroom, flipped a table, breaking the leg of the table and a TV in her bedroom. And so based on that, we're going to ask you to find probable cause for the destruction of property.
Mr. Huey.
Sure, I guess it required statement is pretty much the same as the probable cause statement that I'm looking at it. Yeah.
Except she stated it was her room and
the expert. Her room.
Correct.
Well, I'm not sure if that's any different than the statement that he wrote. Her bench, her room, her bench. Kind of a general statement. That would, I don't know if it changes anything, if it's a room or a bench or if that's an articulable fact.
I think I can take a common sense approach, and I will say that in the reading of this, sometimes perhaps I miss some things, and I think I missed the statement that it was her bench. I was saying a bench at the time. Yeah.
Ruled against me. But it's always nice to have extra articles of facts.
It is, and I think the information that it was in her room at the time in the family home. I think there are sufficient facts to support a finding of probable cause for the destruction, removal of property, the conduct involving the chair and the younger brother. There is sufficient facts to support a simple assault, domestic violence. So I will find probable cause for those two violations. I will enter a plea of not guilty on your behalf, indicate you intend to attempt to retain counsel. Conditions of release, gentlemen?
I'm asking for because you have no criminal law violations to be here for all court dates. I'm gonna ask, I guess I should modify my sentence to you deem necessary. And then I'm actually imposing no contact order. And he not come back to the residence, and that there be a no contact order with Christine Young.
Mr. Healy?
Mr. Young is 24 years of age, lived in the Tri-Cities with his mother pretty much in the Tri-Cities his whole life. He didn't move away from the Tri-Cities in 2015 to attend the University of Washington. He graduated from the University of Washington in 2019 and moved back here at that time and worked for as youth counselor. He knows the facts, synthetic pressure with his background. He doesn't have the office not requesting no contact order. He does not reside with her, but he does see her a lot. Rather not have no contact order. There is a escalation of anger. He would be no, just no contact. We'll let you decide on the no contact order, but it's family. I didn't know about the brother, but I know that too. Just keep the case.
I see in the report that it shows Mr. Christian Young's address is the same address of the location, which is the address of the alleged victim. So what is your address?
So my official address would be the address of my mother. Since the incident has happened, my girlfriend has moved all of my belongings out of my mom's house into a friend's house on 69 Jasmine Avenue in Richmond, Washington. And also, as of today, if I'm released from jail, me and her are supposed to be signing a lease in Richmond for us to get a 2-bedroom apartment.
So right now, your belongings and things all right, 69 Jadwood Avenue?
Yes, Your Honor.
All right, so I am going to release you on your own recognizance on the following conditions. You're not to have any criminal violations or incidents. You're not to have any domestic violence related incidents. The alleged victim is not requesting a no contact order, but you're not to discuss the facts of this case with any alleged victim or any witness. You leave that up to your attorney. Do you understand that, Mr. Young?
Yes, Your Honor.
Your next court date will be April 5th, 2021. We will give you a copy of these conditions of release, that will conclude your case here today. You can have a seat. You know, that Baker case is interesting in that I was in the courtroom in 1990 when Jim Egan made that very argument about knowledge, and the motion was denied. It went up on appeal and it was sustained by the Court of Appeals and then by the Supreme Court as well, that knowledge was implied and it was okay because it was not listed as an element in the charge. Now, here we are in 2021 having an exact opposite ruling by the Supreme Court.
Supposed to know that they should have changed it based on that ruling. That's the hard part for me.
Yes.
Like, how do they know? He said it was okay.
Right. We do have one other individual in custody, Chelsea Johnson. That's cause number XZ05639555. She was on for a shoplifting charge. Probable cause was found in this case. There's a notation that bail was posted, but I think that was earlier. And we reset this from yesterday to today's date. She had refused to come down yesterday. She was here today. I noticed while we were handling some other cases, she got up and left the courtroom without any instructions or comments. And then there was a disturbance in the hallway outside of the courtroom. I not necessarily. I think based on that disturbance, the fact she left the courtroom, I directed Mr. Green, the court service specialist, to have the officers come and take her, because it appeared she was non-cooperative with the process. We'll hold it till Monday without bail until she sees the judge. Okay. Yes. All right. All right. Thank you, gentlemen. We have one last hearing, actually matter on the docket. It is a matter set for a pre-hearing conference with Brian Harmon. I'm going to ask that the clerks allow Mr. Harmon into the courtroom. I'll take a short recess and give Mr. Bell an opportunity to speak to Mr. Harmon about this case before we resume.
Hello? Hello? Okay,
He's on mute now, we still in the courtroom.
are we unmuted now?
Mr. Herman, can you hear me?
Yes, I can hear you.
Okay, I'll just stand, near the judge's microphone here. So my name is Quinville, on the camera briefly so you can see me. I'll return to the microphone here. So I'm the prosecutor for the city of Pasco here. We've just taken a short recess in court so that I can speak with you to see what we want to do with this infraction that's on, and then we'll have the judge come back in and resolve and take care of it. So,
Okay.
so you're here on a driving with a cell phone violation. Do you know
All
your
right.
Do you know what your options are?
I do not. This is the first for me. I'm 47 years old and I've never even had a ticket. So, or 48.
And do you have anything you want to kind of say to me before we start as to like what you were or weren't doing that day, or maybe what the reason?
Yeah, I was. Yeah, I left my hotel. I was there for work and I was using my phone. My phone was my GPS and it was going through my car, my rent-a-car, and I was sitting at a stoplight, and it, like they do, they kick them off, and you gotta touch your phone or swipe it to get your GPS to turn back on. And and I seen that gentleman over there on the sidewalk. I didn't think nothing of it. I was, like I say, I was sitting at a stoplight, and the next thing I knew, I got pulled over, and said that I was using a cell phone while I was driving, which, really I wasn't. I mean, I was at a stoplight and, and I just, activated my GPS.
Yeah. So.
And that's really it.
So it is still a violation of the cell phone to be doing really any more than just kind of a momentary touch. And from the officer's report, he said he had observed the driver texting and scrolling with his right hand while stopping at the traffic signal. That's kind of the report that we have here. So let me.
Right,
go ahead. Go ahead.
No, I was just, what I told you is what really happened. I guess it's, at the end of the day, it's all my word against theirs. But like I say, I've never had a moving violation ever since I've been driving.
So let me walk through your options here with you, Mr. Harmon. So we have a couple. So one, we can mitigate. You just you admit the infraction, and we can lower the fine amount. The second option is to defer. That's a program that's through the state of Washington. You are only eligible to defer once every 7 years, since you haven't had a ticket, I guess, anywhere, let alone Washington. You are eligible. So what that entails is you pay the face value of the ticket, which is $139. You don't have any new infractions for 6 months in the state of Washington. And at the end of that 6 months, if you haven't had any new infractions, the ticket will be dismissed. So, does that make sense, how that works?
Yeah. What was the first option? I didn't.
So it's called mitigation, to mitigate. So we just lower the fine amount, but you basically say you did the ticket, you just don't want to pay as much. That makes sense.
Does it still go on my record?
That's correct. The first method does. So the deferral, it will not go on your record unless you have another infraction in the state of Washington in the next 6 months. So let me continue with your options here. So option 3 is you can have a contested hearing. That's where we have a mini trial where we will bring in the officers and I will kind of call them up on the stand and ask them what they saw happen. They'll say what they saw,
you'll have a chance to ask them any questions or present any evidence that you have to prove that you didn't commit the infraction. And that would be set for another day because we have to get the officers here to be present. Does that make sense?
Right.
So.
Yeah, I mean, it does.
And
I guess it.
Go ahead.
Sorry, go ahead.
Well, so I guess.
No, I just.
Keep talking, sorry. It's the delay on this.
I know, it sounds like probably my best option is going to be option 2 because, it's my word against theirs. And obviously, my word wasn't taken the first time. So, I would say that's probably going to be the best option to where I can keep it off my record.
Yeah, and I can't give you any. I'm the prosecutor, so I can't give you any legal advice or tell you what you should do. I just get to kind of outline your options and
right.
be as transparent as I can. That yes, I will just call the officers up and say, did you see him on his phone, or what did you observe? He will describe hopefully exactly what I just told you, like is in the report. And so that's wholly up to you as to plugging us from there. I don't know how much time you spend in the state of Washington, or if you live.
I don't.
Yeah, so
I live in Wyoming, so.
Your driving record, as my understanding, is that it's pretty much state to state. So I'm not even sure whether your insurance would see a ticket if it's in Wyoming, in Washington, or anything like that, if that makes sense. I certainly understand your concern with it going on your record, but so if that is your hope to try and get it, have it stay off your record, the deferral is a great way to do that. And again, you're only able to do that once every 7 years, but that's within the state of Washington. So.
Right. No, because like I say, at the end of the day, I already talked to the officer that pulled me over the very first time, and he was uncooperative. He was willing, and he didn't listen to what I said then. So I'm assuming that if I spend a whole bunch more time doing with this, I'm not going to have any other end. It's not going to. I'm going to have the same outcome.
Yeah. So the difficulty there with the officer is that this actually involves 2 officers. One, like you said, on the corner who sees the violation. He just radios to the other officer to pull whatever car he saw where the violation is and make sure that was the correct vehicle. So the officer you spoke to didn't see anything. He just got confirmation from the officer that did see it, that it was the correct car. And so he's not really going to be in a position to, be able to give you a lot of information and kind of leeway on that. So.
No, and like I say, I guess the way that I see it is if he didn't tell didn't tell the truth the first time, he's not going to tell the truth the second time. So I guess the deferral is going to be probably the way to go.
Okay. I normally have you sign a paper, but since we're remote, I guess we'll just bring the judge in and let him know that you'd like to defer the ticket. Again, that's going to be at the face value of the ticket, which is $139. So you pay that off within the 6 months, and as long as you don't have any new infractions within those 6 months, it'll be dismissed. And does it ever go on your record? As long as you pay that $139 and don't have any new tickets.
Okay.
Washington.
All right.
If that's your understanding and what you'd like to do, I will let the judge know you can come back in, and we'll get this taken care of for you.
Okay. Do I need to stay on or?
Yes. Just stay on just for another moment.
Okay.
The judge will come in and ask that and make sure that's what you're in agreement with that.
Do you have the case?
Not my copy here, but.
I wonder.
I'm not sure, maybe, I don't know if you want to put it up the wall.
I prepared one.
You, oh, look at you on top.
See, sometimes. I'm worried that I don't have the case here. See, this is,
What does he usually have with it? I didn't know.
he has usually a copy of the ticket.
Make a quick copy from here.
Would you mind?
From his DCH or just leave it? And Mr. Harmon, we're just waiting a moment till the judge comes back in. He's on his way back there.
Okay.
You just move your arm so that he can hear Quinn, so we may have to
Oh.
watch.
All right. All right, are we on the record? All right, this is Pasco Municipal Court. It is 11:28. You can be seated. Thank you. We are here today on a remote hearing. Mr. Harmon is appearing via audio or telephone. Mr. Harmon, are you able to hear me?
Yes, sir.
All right. We're here today regarding a infraction of personal electronic device while driving. I have been handed a order deferring this infraction. Mr. Harmon, have you had a chance to go over this with Mr. Bell?
Yes, sir.
You understand that with regard to this offense, you'll be placed on something that's kind of like probation. That means you're not to have any driving offenses during the next 6 months. If you pay the $139 and have no violations during that period, this matter would be dismissed. Do you understand that?
Yes.
On the other hand, if you have another violation in the next 6 months or you fail to pay the $139, this matter will be found committed and it will go on your record. Do you understand that?
Yes.
And I'll ask, Mr. Bell, did you read this document to him or did you just kind of explain the process? All right, so for purposes of this, Mr. Harmon, you're indicating that you are not a holder of a commercial driver's license. You've never been granted a deferred finding within the last 7 years. and you are making this request today. Is that correct?
Yes.
I'm going to enter the order granting the deferral. Do you need to set this up on payments, or can you pay the $139 in full within the next 30 days?
Yeah, no, that's no problem.
All right. So you will need to provide my clerk's office a way to contact you. Do you have an email address where we can send these things?
Yeah, it's the same one that they sent me all this paperwork before via email. But I can give it to them again. They have both of my email addresses already though.
All right. I'm going to indicate that you will pay this in full by March 26th. And we'll send you
Okay.
copies of these documents that have been entered today.
Okay. Will I be sent something that something that I send back with my payment, or?
You will be sent information about how to make the payment. You can go online or you can mail it to the court, and it just indicates, pay the $139 in full.
Okay.
And you'll also be sent a copy of the order deferring the infraction, so you can have that.
Okay.
All right, that concludes our hearing today. With that, Mr. Harmon, you excused. Have a good day.
Thank you.
All right, I'll sign those documents.